Welcome to you all. Thanks for joining us. I'm Mary Rimmer, and today we also have with us my team's trainee solicitor, Paige Harrison. Unfortunately, due to something last minute that's cropped up, Michael Cressy cannot be with us this evening, but Paige has kindly stepped in at the last minute. Just a bit of background about me and the team. I'm a partner in the private client team at Brachers. I qualified in 2003, and in the team at Brachers, the private client team, there are about 20 of us doing all different work within the private client team, ranging from probate, wills, tax planning, charities, and court protection work, and also trust work. So pretty much everything is covered in our team. I head up the elderly and vulnerable group, and we deal with wills, powers of attorney, applications to the court of protection, and looking after the affairs of the vulnerable and those who can't look after their own affairs. And I also do personally deal with some probate work and provide advice on charity law as well. Outside of the office, I'm a Dementia Friends champion and a volunteer in that role for the Alzheimer's Society. And also I'm honoured to be a trustee of Maidstone Mencap and also of Spadework Limited. So that's enough about me and the team. Over to you, Paige.
Good evening, everyone. We've had quite a few questions submitted, so we're going to try our best to get through all of them. So let's start with some questions on wills. What happens if I don't make a will? I thought the law said my family will inherit, so do I actually need one?
Okay, so where someone hasn't made a will, the fallback provisions are called the intestacy rules. And it's worth noting that there is no provision for unmarried couples under the intestacy rules. So by making a will, it's actually possible for you to ensure that an unmarried partner is provided for example, maybe providing that they can live in the property for life. And in a worst case scenario, if a property in which a surviving cohabitee who is unmarried is owned by the partner who dies first, the surviving partner could actually end up without a home or in difficulty. The intestacy rules also do not allow you to make protective arrangements, for example, for a young person or a person with a disability or other vulnerable people, and you can include that within a will. Also, under the intestacy rules, you would not be controlling how your money and other assets are distributed after your death. So you wouldn't be appointing those you trust as an executor and trustee to make sure that your wishes are followed. Just a quick bit, I won't go into the rules in detail, but basically the intestacy rules state that for married couples, it's only the first £270,000 that would go automatically to the spouse. And anything over that is divided 50-50 between the spouse and children. It's not always sensible. Co-ownership between children and the spouse could be rife with problems. And in a worst case scenario, the children are within their rights to force the sale of a property. Also, as a final note, it's worth bearing in mind that under intestacy rules, children would inherit at 18, which, some people are happy with that, but others may think that's too young an age for children to inherit. Okay, thanks, Paige.
That's interesting. Thank you, Mary. So if I made a will 10 years ago and I'm now married, should my husband make a will too?
So, first point actually on that important one, it's worth noting that marriage actually cancels existing wills unless the will is made in anticipation of that marriage. So if we are meeting with a client and they explain that they are about to marry or there's a chance that they may marry, you can actually draft the will in a way that that doesn't cancel the will. A second point, just to make there, is wills should be reviewed every 3 to 5 years or upon any change of any circumstances. So for example, a birth, death or change in finances, it's worth just reviewing the will. For the person asking this question, they will now most likely intestate because their will has been cancelled. So actually, both of husband and wife will need to make a will. And for a couple, we usually would advise clients to, it's not a second marriage situation where they've got children from other relationships where they're wanting to keep everything separate. Usually, people would actually make a will at the same time. So in that instance, I would say come to us and we would advise you together on making a new will.
So what are the main things that we need to include in our wills?
Okay, so I won't go into obviously the detail, too much detail, because there's a lot to cover today, but some of just the main provisions that you need to think about. So funeral wishes, not very cheerful, but something that is important. If you've got any particular wishes, just giving some guidance to your family. You can put that in the will itself, or you can put it in a side letter. And the main thing is just to make sure that your family know you have got wishes, so that they would check the will before going off and arranging a funeral. So another thing to think about is who you'd want to be your executor and trustee. And the will would usually appoint appropriate people to act. And it's an important decision. It's quite usual to appoint a surviving spouse on their own, or with other, maybe with children, adult children, family or friends. You could also appoint a professional. So for those making wills where they have young children, perhaps the most important thing really to think about is who you'd want to act as a guardian. And they would have day-to-day care and control of the children. That would only be on the death of both parents that would take effect. You'd also need to think about personal belongings. And again, you can include that in the will, or you can include it in a side letter. It's not legally binding, it's purely wishes. But if it's in a side letter, but it's actually really flexible. So I think most clients, when they come to see us, probably tend to put it in a side letter. And then that way, if they've got wishes that change, maybe they've got another item or replaced something, then they don't have to keep paying to update their will. Okay, so other things that you could include, cash gifts, either to individuals or to charities. If you own business or agriculture assets or foreign assets, then you need to get some advice on the best way of ensuring that you've dealt with those properly as well. And then another key provision is, what do you want to do with your estate? So your money, your property, where do you want that to pass? And there are various options. You can either leave it outright, for example, to people or charity, or on some form of trust. And I'm going to touch on that in a moment, I'm sure, because that's one of the main points of tonight, is looking at trusts for your loved ones as well. And that's it, Paige. Thank you.
Yes, that brings us very nicely onto our next question. So, what kind of trust can I include in my will? And more precisely, what is the best way to leave money in a will to a disabled child who will likely lack capacity for finances? Can I do this without affecting their benefits?
Okay, so if you're looking at a second marriage or relationship, there may be children from several relationships that need to be provided for, and the legal mechanisms for doing that are available, particularly life interest trusts, and that's a common way for providing for a second wife or husband situation where there's children from a first marriage, and also it's something where you could think about providing for children with discretionary trusts as well. So quite often when I meet with clients who have a disabled child, they will say, it's all right, I don't need a trust. I'm going to leave everything to my child who is disabled, and we trust them completely. They love their brother or sister and they will take care of them. But actually that isn't something that we would ever recommend people would do, and that's probably for the following reasons. So if the child that you then have left money to were to die, or get into marriage problems and divorce, or became bankrupt, that is risking the inheritance that you're actually hoping would go to your other child. Also, it is possible for the local authority to make a claim against the estate of the deceased parent, where they feel that a disabled child has not been properly provided for. So again, that can cause more problems than it actually solves. And a way of avoiding this commonly is to include a trust in your will. So, for example, a discretionary trust, we use them in lots of different circumstances. For example, it could be because somebody's not particularly good with money, or you want complete flexibility, where you're entrusting people to look after the money, and you would leave a letter to them explaining how you would like them to benefit your loved ones. So it's really flexible. It gives the executors, who usually then become the trustees, although you can have different people if you wanted to, it would give them really wide powers to be able to look after the needs of the people you want to benefit, your beneficiaries. With a discretionary trust, the trustees can actually distribute income and capital separately to beneficiaries as they see fit. And so what you would do in your will, for example, if it was by your will, you would leave in the will, you'd state who you'd like to benefit, potentially, and then in the side letters to your trustees, you would explain how you'd like them to exercise their discretion, and maybe give them some more guidance. But really, it's up to your chosen trustees. I won't go into it again now, but obviously if you're coming to see us about making a will, we could also speak to you about disabled persons trusts, because that is also a way of looking after disabled beneficiaries in a tax efficient way, but the rules are quite complex, so it's not something I think really that I'd want to go through with you now particularly, but obviously if that client wanted to come and see us, we'd be able to talk them through it. Thanks.
So I have a question about trustees specifically now. How
Okay.
easy is it for a trustee to get access to the money?
So the trustees will be responsible for looking after any ongoing trust, and then they can access the money in the trust for the benefit of the beneficiaries. So if there's property, they'd be looking after the property in the trust or dealing with investments, usually with guidance from an independent financial advisor. You can have professional trustee. So quite often we have that where we would have clients that would actually like to have a mix of maybe family and Brachers, or you could have an accountant, just to have that independent, I suppose independent viewpoint. And also with a solicitor, you've got somebody who would be able to look after the trust and give you guidance as well while the trust is running. So it depends what assets are in the trust. But the trustees, if there's cash there, for example, then the trustees can access that money to use it for the benefit of those beneficiaries.
So if we could talk a bit more about discretionary trusts now. So what should a discretionary trust in a will look like? So for example, we've got a question here saying we paid for one a few years ago, but we only seem to have received a will.
Okay, so if the trust that you set up was actually incorporated in your will, then that is the document. So usually you would have the trust set up within the will, and it would set out the terms of the trust, who the potential beneficiaries are and who the trustees are, and then you would have a side letter giving that further guidance. So actually you may not have a separate document at all. That's probably what's happened in that case. That it is within the body of the will itself.
Okay, that's good to know. Thank you. So do I have to have the trust in my will, or can I set up a trust now?
So we do quite commonly set up the trusts within wills, but you can also set up a lifetime settlement. Will trust doesn't take effect until the death. So the advantage of that is that there are no running costs, and actually it can be taken back out of the will. So if it's not relevant, it can just be the will's updated at a future point and that trust is taken back out again. A lifetime trust can be useful. It can be, for example, if other family members want to leave funds to one of your children, for example. You can have a lifetime trust as well if you want to get money out of your estate. So for inheritance tax planning purposes, if you have that money that you're able to kind of get out now and you wanted to, you'd be able to set up a trust now. Sometimes as well, people can set up a pilot trust, and then in your will you could actually state that your part of your assets should go to that trust that you've already set up, and you'd have to kind of name it properly. But as I say, most of the time when we do it, it tends to be that you'd actually have the wording and that trust set up within the will itself.
Okay, so our next question is, what is the procedure for including childcare responsibilities in your will for after you pass away?
So I mentioned it briefly, but basically it's guardianship. So you can name individuals to be guardians for your minor children, so those under 18. So in the hopefully unlikely event something were to happen to, for example, both parents, then you'd actually state who you wanted to be appointed as the guardian. You can also, again, leave instructions in a letter. So if there's anything particular that you wanted, and it's quite horrible to think about, but if there's anything particular about, for example, education or where they would live or who they would see, then it's worth putting that into a side letter as well.
Okay, I have another specific question here. So, we are parents to a disabled child and we don't have a will in place. What are the costs to do this and how does the process work?
So obviously I can only tell you about our fees, and it may be that you have existing solicitors that you use, and but obviously would be very happy to help if you want to come to us. But our fees depend to some extent on your circumstances and wishes. So if you want to find out how much the wills would cost if we were asked to advise you on them and prepare them for you, get in touch with us. We can obviously talk you through some of your circumstances and give you an idea. We're also offering a discount today, and you'll have details after today will come through to you. But a starting point really for the fees, I'd say an average, if you've got a couple for mirror wills where there are no ongoing trusts, you'd be looking at maybe around £600 plus VAT. At the other end of the scale, if you had more complex wills with trusts, maybe a life interest trust for each other, which again, we'd explain to you the benefits of having that in place, and then maybe a discretionary trust like we've talked about, then you'd be looking at fees perhaps in the region of £1,500 plus VAT. So it really varies depending on your circumstances and also what you're trying to achieve. And actually, as to the process, we can send out a link to an online questionnaire. And then from that, we gather most of the information that we need. So it gets you thinking about what information you're going to need to provide to us, about your assets, about your family, about anyone that you don't want to inherit and that you want to make that known if there's any problems. And then the process usually would be that we would get you to complete that online questionnaire. That would then give us some of the information and we'd work out the most appropriate person to deal with your wills. We'd then book in a meeting. We are doing meetings in person, but it could be a Teams or Zoom meeting, for example. And then we would discuss the instructions with you, make sure we know exactly what you want and what you require. We'd go away and do the drafting, and then we would send that to you for you to review. And then usually you'd come back in to sign it. Or, if you weren't able to for any reason, we could talk you through signing it with your own witnesses. And then that's it. Once that's done, again, usually we would then keep the original wills for you and give you copies to keep at home, or if you wanted them, we'd give you the originals to keep. And it's as simple as that, really. It can be a very quick process. I think some of it depends to some extent on, obviously everyone's different, but sometimes I think people start things off and then it goes a bit slow because people want to have a think about it or don't like thinking about it. But it actually can be quite a quick process, really, quite painless as well.
That's great to know. Thank you, Mary. So, I've been told that the Mental Capacity Act 2005 is an important act for me to know about. What is it about and what does it cover?
Okay, so the Mental Capacity Act 2005, it creates a framework which sets out how decisions should be made by and on behalf of people aged 16 and over who lack capacity. And there are, I won't go into it, and again, it's long. There's a lot of guidance, but I'll just touch on some of the key aspects of it. There are 5 key principles, and I think that's the kind of the main points to think about now. One is a person must be assumed to have capacity unless it's established that he lacks capacity. 2, a person is not to be treated as unable to make a decision unless all practicable steps to help him do so have been taken without success. 3, a person is not to be treated as unable to make a decision merely because he makes an unwise decision. 4, an act done or decision made under the Act for or on behalf of a person lacking capacity must be made or done in their best interests. And then 5, before the act is done or decision made, regard must be had as to whether it can be achieved in a less restrictive way. So they're the kind of 5 principles of the Mental Capacity Act. So looking at a person lacking capacity, so a person lacks capacity in relation to a matter if at that time, that material time, they are unable to make a particular decision for themselves in relation to the matter because of an impairment or a disturbance of the functioning of the mind or brain. And it's time and issue specific. So you'd need to, on each specific decision, look to see whether they lack capacity. So it's, it's quite detailed. And I think the main point of it is it's trying not to just say, I think people used to have a tendency of saying somebody lacks capacity and that was it. You just took away everything from them. And actually this is giving that you still need to consult with people. You still need to take into account their wishes. There is a 2-part test. Firstly, that there is an impairment or a disturbance. And then secondly, that is actually impacting upon that person's ability to make a decision. So if somebody can't make a decision, then they won't be able to understand information relevant to the decision. For example, thinking about the actual consequences of deciding one way or another. They won't be able to retain that information for the time necessary to make a decision. They won't be able to use or weigh up the information as part of the process of making their decision, and they won't be able to communicate it. So that's kind of parts of the looking at the test, really. So a person must not be treated as lacking capacity just based on their age, appearance, condition, behaviour, because that might lead to an unjustified assumption about their capacity. So just for example, somebody has a diagnosis which might impact upon their mental capacity. It doesn't automatically mean they lack the capacity to make all decisions. They still may be able to make some decisions. The Act also sets out it's called a best interest checklist, which outlines what someone needs to consider before taking an action or a decision for someone else. And I think it's quite useful just to have a really quick look through that. So it would involve looking at an individual's wishes and feelings, and that's both current and past as well. Maybe if they had capacity at one time and they've now lost capacity, then you'd look back to see what was important to them. You'd also consider all the circumstances relevant to them. For example, what type of mental health problem or what type of disability or physical disability that they have. How long will it last? How old are they? Whether they would normally take this decision themselves, whether they're likely to recover capacity in the future, who's cared for them or who is caring for them. So there's lots of things to kind of look at. You'd also then need to consider whether they would have capacity to make that decision in the future. Could you, for example, put off making the decision now because their inability to make a decision is only short term? So can you actually delay making a decision until they do have capacity? And also, can you support them to make a decision? So rather than just making it for them, can you actually work with them to come to, a decision together, basically? So it's quite, as I said, there's a lot to go through, but that's just some touching the surface of it. It is a really important act, and it does come within a lot of, powers of attorney and court protection work. That's something that we all refer back to. I don't know if that covers it enough, Paige, without too much, detail.
Yes, that's very reassuring to hear all of that. So we've spoken a bit about the Court of Protection, but what is the difference between the Court of Protection and the Office of the Public Guardian? What are they and what are their roles?
Okay, so the Court of Protection was established by the Mental Capacity Act 2005, and it's basically a superior court of record, and it has the same powers, rights, privileges and authority as the High Court. And its jurisdiction is to make financial and welfare decisions on behalf of people who are mentally incapable of making it for themselves. So the court would decide whether someone has a capacity to make that financial or welfare decision. It makes declarations, it makes orders about financial and welfare matters. It appoints deputies, So where somebody lacks capacity and they haven't got a power of attorney, for example, there may be a deputy appointed. It can remove deputies and attorneys who are failing to carry out their duties. And it will also make decisions about enduring and lasting powers of attorney, whether they're valid, and also orders about deprivation of liberty as well. So that's some of the key things that the court would cover. The Office of the Public Guardian has a different role. It maintains the register of powers of attorney and deputyship orders, and it requests and receives reports from deputies, and then the public guardian will actually make applications to the Court of Protection for the removal of deputies and deals with how deputies are exercising their powers as well. So there is that kind of crossover interaction, but there is a distinct difference between the two, the court and the Office of the Public Guardian.
Okay, so our next question is, I've already made an enduring power of attorney in 2005. Is this still valid? And what are lasting powers of attorney?
Okay, so enduring powers of attorney is the old type of power of attorney, which was pre-October 2007. So it's still valid if it was valid then. So, sometimes we do sadly come across powers of attorney where there was something that actually meant that it really, sometimes we even find that they haven't been signed by everyone, and sometimes not even the donor or the person making it has signed. So if it was valid, then it's still valid, but sometimes it can be that they're out of date or it's not covering all the situations that you would now need it to. So for enduring powers of attorney, there's quite often a benefit to people reviewing them and then maybe looking at replacing the financial, the enduring power of attorney with the financial lasting power of attorney, which is the newer type of power of attorney. So also what we do sometimes with clients is where they may actually will talk through and look at their enduring power of attorney and we'll say it's still valid, maybe say it appointed the children and that's still what the person wants to do. It may be when we talk through it that there's no need to change it, that they will actually, the clients will say, I'm going to stick with my enduring power of attorney. But then what we would then look at doing and advising the client to do would be to look at a health and welfare lasting power of attorney, which they weren't in existence at the time people made enduring powers of attorney. You couldn't do that. You could only cover your financial position. You couldn't do anything with your health. So that's another kind of key thing for somebody to look at if they're reviewing their enduring power of attorney. The property and financial affairs power of attorney now allows you to give your attorneys the authority to act in relation to all of your personal affairs in relation to your property, the same as the old enduring power of attorney did. So they could, for example, make decisions about paying bills, selling property, dealing with your bank accounts, investments, pensions, benefits, all of that exactly the same. But it doesn't allow decisions about where you'd live, your well-being, life-sustaining treatment. That's where you need to have the health and welfare lasting power of attorney. Just quickly running through lasting powers of attorney. So for both types, quite often we tend to have clients that would have the same people acting under both lasting powers of attorney. They're two separate documents, so you can have different people if you want to. And they're really flexible, so you can actually cover lots of different scenarios of, for example, if you wanted to state any preferences or instructions, giving guidance to your attorneys, we can talk you through that, put that into the powers of attorney or in a side letter. So I would say, although an enduring power of attorney may still be fine, for most people, once we've had that chat, they would then say, actually, I think I'd rather update and get it all kind of current, and would make that switch over to lasting powers of attorney.
Okay, I've got quite a specific question here. So I applied a year ago for both health and welfare and property and financial lasting powers of attorney. Why am I still waiting for the documents as they are signed and paid for?
Okay, So obviously I can't comment on that particular, individual circumstances, because it may be that the person's tried to do the powers of the attorney themselves, because you can actually do them yourselves. Sometimes we find that, no disrespect to clients, but sometimes we do find that best will in the world, family members say, oh, I'll help you to do your power of attorney, and actually it all goes wrong because they are quite fiddly forms. I mean, even when we prepare them, we find clients, even on the signing, sometimes get it wrong. So we pick up on that. We try to prevent there being an issue, but it could be that something's happened that's caused a delay. COVID, unfortunately, has caused a delay with the registration of the powers of attorney as well. So it could be that, there is that delay at the Office of the Public Guardian who deals with the registration. It could be that that's where it's got caught up. So I would say in that instance, go back to, if it's a solicitor who's prepared it for you and dealt with the registration, go back to them and try and find out what's happened. It may be they'll come back and say, I'm really sorry, it is with the Office of the Public Guardian and they are experiencing such delays that's why we've not got them back. But it's worth getting it checked out. Also, if anyone wants us, obviously, to help if they have tried to do something themselves and it's gone a bit wrong, come to us and we can have a look as well and see if we can help fix it.
That's great to hear. Thank you. So, what if someone can't make a power of attorney? For example, if they don't have enough understanding and mental capacity to do so, can anyone help them with their finances?
So, where a power of attorney has not been made and then somebody loses mental capacity so they can no longer make one, they don't have enough capacity to sign it, then an application can be made to the Court of Protection for a deputy to be appointed. The deputy would be somebody appointed in the role of looking after, for example, their financial affairs. And that's where the Court of Protection can actually step in. And they would basically the deputy can make decisions about in the best interests of that person who lacks capacity. And that deputy would usually be appointed where somebody has either not got a valid power of attorney, or maybe sometimes where there's disputes, sometimes the court, or if somebody's acted inappropriately, it will actually be that the attorney can be removed and a deputy appointed. So it's not too late. If somebody hasn't made a power of attorney, the deputy can be appointed, and that could be a family member or a friend, or it could be a professional. So it could be, for example, solicitor, and it could be, for example, Brachers. We do actually apply sometimes with a family member, so that we would apply for us both to be appointed as a deputy. Sometimes we make the application for a lay person, family member, to be appointed as the deputy. And then we can obviously support them if they needed help after their appointment. The court tends to prefer appointing a member of the person's family if they can, unless it's, there isn't anyone appropriate to act. But sometimes it is more appropriate for a professional deputy to be appointed, and that could be if there's hostility between family members, a bit of disagreement about who's going to act, or if there are people that if it's a large estate, for example, a large estate where maybe a lay person would struggle to deal with that level of responsibility, sometimes then it's going to be more appropriate for a professional deputy to be appointed. It's really, I suppose, if you've got a power of attorney, it means that you've got control. You've stated who you'd want to act for you while you have got capacity, because with the power of attorney, you can actually have help while you have capacity if you wanted to. But it's there as an insurance policy that if you never needed to use it while you have capacity, if you lose capacity, you've named somebody who would help. The deputyship is there really to kind of pick up if you've not made one, that you're not then left alone. You are actually then having somebody appointed for you to help. I don't know if it's worth just me with that page, actually. Sorry, I was going to say, I don't know whether it's worth me just saying a bit about how long it could take. The court aims to make an order within about 16 weeks of receiving the application, but it really does depend on the volume of applications that the court has to deal with, and it's usually a lot longer than that. Also, then we obviously have to prepare the documents. So if somebody comes to us, usually what would happen is client would come to us saying that they've got a relative, so a parent that needs to be looked after. We would then make the application for them. They would sign the forms, we send it off, then there's a whole kind of procedure, a court procedure that has to be followed. And then if everything goes to plan and the court grants them the deputyship order, then at that point it may be that they go away and they're quite happy with dealing with that, or we would help them ongoing with any advice that they need after they've been appointed. Costs wise, it can be quite expensive. So there are our fees. So if we were advising somebody on this, we would charge. There's also a court application fee of £371. There's also assessment of capacity. So we need to get a document to show that somebody doesn't have legal mental capacity, and you need to get that done on a particular court form. And there's usually a charge for that as well. It can be about £400, £500. So it's not, it can be quite drawn out time-wise to get this done, and it also can be quite costly. But if you haven't got the power of attorney, it's your only option really to get this in place for somebody. I know, sorry, that's a long answer, but there's a lot to it with deputyships.
No, that was very helpful. Thank you, Mary. So can someone be appointed to look after health and welfare decisions too?
Yes. So welfare deputies can be appointed by the Court of Protection to make personal welfare decisions on behalf of somebody who lacks capacity. But the numbers appointed are very low compared to those who are appointed as a property and financial affairs deputy. So in practice, I think nearly all acts of care and treatment are carried out informally and collaboratively by individuals or groups of people working together on behalf of the person who lacks capacity. So you may find that actually in practice, it could be family members, social care workers, health professionals can actually provide care and treatment without having to get that welfare deputyship in place. So it can be things like personal care, moving someone into a residential home, carrying out medical, dental tests and examinations, performing life-saving surgery, can all be carried out without the need for a welfare deputy. But sometimes it's appropriate for a welfare deputy to be appointed, and it could be, for example, that there's something specific to their care, maybe very complex care, that means that you'd need to have somebody appointed by the court in that role, or if there was some kind of disagreement about the treatment that someone was about to receive, it may then be that is appropriate to go to the court and ask for a welfare deputy.
Okay, so are there any other kind of situations where a welfare deputy may likely to be appointed?
Yeah, so I mentioned there about complex health and social care needs. So it could be if you need somebody, a reliable, knowledgeable person to liaise with all the professionals and care workers to avoid breakdown in the care of that person. It may then be that you need to have an application made for a welfare deputy. It could be if the person has particular communication difficulties, and the welfare deputy possesses those communication skills that are necessary to be able to communicate with them and to convey their wishes, and wants to be involved in helping arranging providing care. It could also be where decisions to be taken are more frequent or complex than a usual decision that would be made for somebody. For example, if there's going to be a number of different medical treatments required in a short period of time, and it would be impracticable to keep going to the court for those decisions, it may then be that you can actually ask the court to appoint a welfare deputy. And also it can be where person is at risk of serious harm. It may then be that the court would appoint a welfare deputy to step in and look after them. So that's kind of the the key times where the court may actually, rather than dealing with a one-off decision, which you can do, where they'd actually just appoint a welfare deputy.
So if a welfare deputy has been appointed, what kind of decisions can they make?
So going back again, Mental Capacity Act 2005, so it requires that if the court makes any order, it should be limited in scope and duration. So many decisions which a welfare deputy may seek to be made could be made by the court as a one-off. So for example, an order setting out where a person should live, it could be that the court just decides on that one particular decision. As the person's mental capacity to make personal welfare decisions varies, depending on the decision which needs to be made, the order would quite often limit the welfare deputy's authority to those decisions to the ones where that person cannot make them themselves. So it tried to be quite specific. So for example, a person may have capacity to consent to a medical examination, but lacks capacity to consent to an operation which is required as a result of that medical examination. So in general terms, just some of the things that would cover, welfare order would allow a deputy to decide some of the following, and I'll just list a few things. So be where a person should live and with whom they should live, decisions about day-to-day care, consent to medical and dental examinations and treatment, and arranging the provision of care services, deciding whether that person should take part in leisure and social activities, making complaints for them about that person's care or treatment. The decisions the welfare deputy cannot make would include directing a different individual to take over responsibility for healthcare, making decisions inconsistent with lawful decisions made by the person's financial attorney if they had one, making decisions, giving consent to specific treatment. So if the person's made a valid and applicable advance decision where they set out about their refusal of certain treatment, you can't kind of override that with your instructions and decisions. Refusing consent to the carrying out or continuation of life-sustaining treatment, and using unnecessary or disproportionate restraint, including the use of threat or force, restriction of movement. So there's some of the things you couldn't do with your welfare deputyship.
Okay, our next question is, what happens when my child turns 16? Can I continue to look after them then and help with their financial matters? And does this continue after they reach 18?
So when young people turn 16, it may be that they're entitled to some benefits and financial support in their own right, even if they're continuing to live at home with parents. And the available benefits depend on whether they're in education, looking for work, claiming disability benefits, whether they need to pay for care. So there's lots of different factors that would need to be considered. And you'd need to work out whether it makes more sense for your child to claim the benefits or whether you would claim them as for them. So that would be something you'd need to get some advice on. If your child lacks capacity to make decisions about finances or to claim benefits, then you would need to make arrangements so that you or someone else can do that once they reach adulthood. So until a disabled child reaches the age of 18, in most cases, parents would have parental responsibility for the child and they would make the decisions for them. But once they've reached 18, then the legal position on decision making changes. And so parents then would usually lose that parental responsibility and no longer have any legal responsibilities or automatic rights to make decisions about their child. So in England and Wales, because the law is different outside of jurisdiction. So England and Wales, with regards to decision making, the starting point for a disabled individual and their parent to consider is to assess each decision separately and establish whether they can make that decision for themselves. Obviously, that's mentioned it earlier, but that's a key principle of the Mental Capacity Act 2005, which states that it must be assumed that everyone has the capacity to make a decision unless it can be shown that they lack the capacity to do so. So if it's clear that your child isn't able to make that particular decision, then the decision must be taken on their behalf. And the Mental Capacity Act, again, sets out how you would do that. and it depends on what decision it is being made. So you'd need to get some guidance and look back at the Mental Capacity Act and the code that goes with it. So with benefits, if your child is receiving benefits, you'd need to check with the Department for Work and Pensions if you're the appointee, if you're the person managing them. You may find that once your child reaches 18, organisations where your child has money, so it may be that they have got accounts, something's happened, and they had an account, maybe people have paid money for them. You would need then to go to that particular bank and find out what their requirements are. And usually they would then want that child to take responsibility of the account, and they would only accept instructions from that child who's now turned 18. So if your child doesn't have the mental capacity to be able to manage the assets, at that point, that's where you'd be able to apply to the Court of Protection to request that you basically become their deputy for financial matters. And then the court would consider the application, and if it's granted, that is what gives you the legal authority to deal with their finances. An application for deputyship would be considered by the court, and if it's approved, they basically issue you with proof. So it's a deputyship order appointing the deputy, and it sets out sometimes what the deputy can and can't do. And that's the legal authority that you would then need to be able to deal with finances on behalf of your child. So it's not entirely straightforward. It's something, it's workable, but you would need to get some advice on it.
Okay, that's helpful, thank you. I have another specific question here. So can I be appointed as a welfare deputy for my daughter who is 17?
So there was a test case a couple of years ago concerning the appointment of a personal welfare deputy, and that attracted a bit of media coverage at the time. The problem that the families saw stemmed from, and I mentioned it, their shock at realising that their parental authority for their child with learning disabilities ends on their child's 18th birthday. So many families in that position would be anxious to secure welfare deputyships to formally recognise their relationship, which is usually one of lifelong loyalty and care and dedication. So welfare deputies are rarely appointed, so there's less than 2% of total deputyships. And the Mental Capacity Act Code of Practice says that they will only be required in the most difficult cases where important and necessary actions cannot be carried out without the court's authority, or there is no other way of settling the matter. So the families argued instead that the court should adopt a test that flows directly from the Mental Capacity Act and consider the person's best interests, with an emphasis on what that person themselves wants, which they anticipate in most cases would be that the child would say they'd want their parent to carry on, or a close family member to be the person that helps. So the effect of the judgment, it doesn't automatically make it easier for parents and close family members to be appointed as a personal welfare deputy for their loved one. The law provides that the issue of whether or not to appoint a deputy is a best interest decision, and the judge has to consider all of the Mental Capacity Act principles, and it also has to consider that the decision of the court should be preferred to the appointment of a deputy, and that if a deputy is appointed, their powers should be as limited in scope and duration as reasonably practicable in the circumstances. So the least restrictive, basically. The judge in that case noted that the extension of parental responsibility beyond the age of 18 may be driven by a natural, healthy parental instinct to step in and look after your child, but it should be guarded against. And he went on to say that the imposition, and I've got the speech here, the imposition of a legal framework which is overly protective risks inhibiting personal development and may fail properly to nurture individual potential. So the judge felt that the most likely conclusion in most cases would be that it isn't in the best interests of that child for a personal welfare deputy to be appointed. So the judge acknowledged it's understandable parents want to carry on their parental responsibility for their young child, beyond the age of 18, but it's still not caused a complete shift over into there being more welfare deputyships. It's still on a case-by-case basis, and it's, I think, in most cases where we don't really find that many welfare deputyships being granted. I know that, again, another long-winded one, but I hope that kind of answers it.
No, that was really helpful. Thank you. So I'm down to our last question. It seems quite an important one. So, what if my loved one has not made a will or has a will which is out of date, but I don't think that they would now understand what it means to make a will? Is it too late to make a will?
Okay, so first of all, quite simply, no, it can be possibly dealt with. So with regard to making a will, and I touched on earlier about the different things that you'd need to include and the process for doing it, but at the very, I suppose, the very essence of it, it needs to be that somebody has what's called testamentary capacity. And that's the legal term that's used to describe somebody's legal and mental ability to make or alter a valid will. So generally speaking, if the person making the will lacks testamentary capacity, then the will would be invalid. And the test for capacity is based on case law. So there's an old case called Banks and Goodfellow from 1870. So we're still reliant on that. And what that says is the person making the will, the testator, must understand the nature of making a will and its effects. They must understand the extent of the property of which they are disposing. They must be able to comprehend and appreciate the claims to which they ought to give effect. And they must have no disorder of the mind that perverts their sense of right or prevents the exercise of their natural faculties in disposing of their property by their will. So the level of understanding required by that test varies according to the complexity of the will itself as well, and also the testator's assets and the claims on the testator. So if somebody, say your loved one, hasn't made a will, or they have a will that's out of date, and they don't now have mental capacity to make a will, then again, going back to it, it's the Mental Capacity Act. The Mental Capacity Act 2005 states what should happen, and that's where the court can order the execution of a will on behalf of that person if they're over 18. You'd need to get medical evidence confirming the lack of capacity, and it needs to be very specific. So again, if somebody came to us, we'd talk them through what's required. And it's called a statutory will. So that's usually needed where somebody either hasn't got a will and the intestacy rules aren't going to do the job, so they're not going to adequately cover that situation, or maybe where there's an out-of-date will. Somebody has got one, but now looking at it, actually it doesn't do what's necessary. It could be there's a change of family circumstances or second marriage or death. The court needs to be sure that that proposed will is in the person's best interests, and it takes into account their present and past wishes, beliefs, values, feelings. It would also, there'd be taking views of third parties, for example, carers, looking at previous wills, any other written statements would be taken into account. So really detailed, looking at what that person would have wanted to do had they been able to make a will. During the course of the application, the court needs lots of different documents provided. So when we do statutory wills for clients, you have to attach various exhibits, as we call them, including a copy of the proposed will that you would saying to the court that that's what you would propose would be signed, or a codicil if it's something to kind of add to an existing will. You'd need to enclose copies of existing wills or codicils. You would need to give a family tree, so a detailed family tree of who there is. For example, if you have an intestacy situation, if someone doesn't make a will and you're now saying we should be making a will and it's different people, you need to show who is being treated differently. So who is missing out basically on the intestacy rules, what would happen by you now putting in place a new will. You need to give quite detailed financial information about their care needs, their income and expenditure. So it's really quite a lot of information needs to be gathered together. But it is possible. So it's not too late if somebody hasn't made a will. Sometimes, as much as I said, don't rely on the intestacy rules, sometimes the expense of doing a statutory will has to be looked at in relation to what that person owns. So if somebody doesn't actually have that much, statutory wills aren't cheap. Again, takes some time to get in place unless it's a real emergency one. So sometimes it's weighing up the cost of getting it against what somebody actually has that's been covered by the will. But it is possible to do it, so it's not too late, in brief. But I think it's one of those things that, it's not always relevant to people, but we do deal with them, quite often for clients where it is appropriate for us to try and get something reflecting what they would want.
Yeah, that's great to know and really helpful. Thank you, Mary. So that's the end of our questions for today. Thank you very much for taking the time to submit them. If you have any further questions, please do get in touch and we will do our best to answer them. And if you'd like to get in touch with us about making a will or power of attorney or advice regarding deputyship, you'll be emailed details of how to use our 10% discount after this question and answer session. So, Mary, have you got any last points to add?
Only a couple, just to say thank you very much, Paige, for stepping in at the last minute. It was really appreciated having you help with this. And it was a shame not to have Michael, but you did a brilliant job, so thank you. And to thank Mencap personally, being part of Maidstone Mencap, but actually for their support in this as well. And then to thank everyone who's come along as well, because it really is, to me, it's important that people get some advice. It doesn't matter if they want to then go away and go back to who they've used before. We'd be very happy to help people if they want to come to us. We've got a specialist team, but it's really just making sure people know a bit about what they need to consider, and not all of it is straightforward, but if you get some legal advice, I think it can be, with the help of us guiding you through it. Obviously, you said about if there's anyone that wants to go back over today or wants to pass on today's information to anyone who wasn't able to make it, I believe we are doing a recording just of us doing this Q&A session, which will also be circulated after by our marketing team who are helping with that. And so really it just is thank you for coming along, and I hope it's been of some help. Thanks, Paige.
Thanks, Mary.